What do you think, Commissioner?
Plain state.
Plain
But
state.
they said my release date was just like the officer that brought me in. But I was released on the second from Plain State.
Okay, so your release, Plain State.
Okay, we call cause number 19-33599, the state of Texas versus Alexis Dixon. That's you. And you were here with your attorney and the state's attorney. What we have most recently is a third amended motion to revoke a probation. That's seldom seen here, a third amended, but nonetheless, it can happen. Are the parties ready to proceed here? Does the defendant waive a formal reading of this, and can we proceed by summons?
We're ready, Your Honor, and we can proceed by summons.
Please raise your right hand, ma'am. Do you solemnly swear or affirm any statements that you might make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, lower your hand. There's no agreement on this?
No, Your Honor, it's just related to discretion.
All right. This third amended motion to revoke probation in summary, ma'am, states that on June 2nd, 2021, you were sentenced to 10 years in prison, probated for 10 years for the state jail felony of theft. Now that is a higher than state jail felony punishment that you were placed on. You must have had prior convictions. I don't even have to look. I'll bet you pleaded true to prior convictions. Yes, I'm looking at the indictment. You pleaded true to paragraphs 2, 3, and 4, which were 2017 convictions out of Shelby County, Texas, for theft, burglary of a building, and controlled substance. What happened was that state jail felony, the punishment then of the state jail felony became enhanced as though it were a third degree felony. So you were looking at up to 10 years imprisonment. Thus, you were sentenced to 10 years in prison, probated for 10 years. Have we had hearings on this before?
I mean, Your Honor, we need to.
We're just going to go to the third amended?
Well, I can explain kind of what happened.
Okay, help me out.
Are we on YouTube?
Yeah, we are. As much as we can be. Hold on.
Could you?
To build coping skills that don't have anything to do with covering up with substances. Helps me talk about things in front of people without shutting down. I actually was a peer leader. I was a senior recovery advocate there, so I talked to the other women on the microphone, and they really listened to me.
Okay.
The way I talked to them. So.
All right. So, are you confident you're in a better place now?
Yes, in my mind.
You're going to make more
And I have
mature decisions that are in conformity with the law.
Yes, sir. I have a job lined up, an actual job with, Social Security taken out and things like that.
Yes, ma'am.
I have a new home to go home to. I have good family support because they believe in me. So.
All right. Okay. Well, anything else anybody wants to add?
Nothing to stay here.
I'm going to find that the defendant has pleaded guilty voluntarily, knowingly, intelligently to allegation number 17, I believe, which is in the third amended motion to revoke probation, committing the offense of theft of property in Liberty County, Texas, of an amount over $30,000, but less than $150,000, occurring on or about March 21st, 2024. She has entered her plea of truth voluntarily, knowingly, intelligently. That is enough to grant this third amended motion to revoke probation by a preponderance of the evidence or greater. Your probation is hereby revoked. And this court has listened to the recommendations of the attorneys and as to punishment. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years for this state jail felony, punished though as though it was a third degree felony because of your prior felony convictions that you pleaded true to at the time of sentencing. And the sentence shall run concurrently with other sentences. So, do you understand what has Well, the only other thing is, I mean, dot all the i's.
And there was no
Is there any
restitution.
restitution?
No, sir.
Okay. That's, I take care of it. Anything else? Do you understand what has happened today?
Yes, sir.
Fix this mess that you put yourself into. You obviously know better, and you have the tools to do better. So there's no excuse for failure. Failure's not an option with you. Be successful in your life. Can you?
I'm gonna give it my best shot.
No, you want to
Yes,
do
I
it.
can.
Everybody says, I'm going to try.
Well, I'm gonna
But
do
you've got to get over the bar. But the bar's set low enough, everybody can. You can too. Do it.
Well, she
Just
was
do it.
No, I don't like it. It was horrible.
All right. Anything else? That is all. Thank you. Good luck, Nancy. Uh-oh, we need a thumbprint.
It's just a moment. I want to make sure.
Come forward, please. How do you pronounce your first name?
Michael Raven.
Okay, but it's two names though, right? So Michael and Raven, but it's Ravine, not Ravine. It's Raven.
Yes.
Okay.
Yes, sir.
Peterson.
Yes, sir.
All right. You are here with your attorney, Mr. Kimler, and the state's attorney, and your probation officer. Here in 23 CR 153, we've got two things here. In 153, there is a first amended motion to revoke probation that was filed on the April 22nd of a year ago. And then we've got a new indictment in 24 CR 530 of a third-degree felony of harassment of a public servant that was filed, handed up by the grand jury on March 6th of 2024. And my guess is that first amended includes that new indictment. Maybe let's see. Yeah, allegation number 3 is out of these 8 allegations of wrongdoing here. Okay, so what today? Have a hearing?
Well, I'm sure the state's, she's going to plead untrue to the offense, and I'm sure Mr. Boyd would want an opportunity to prove that out.
That's correct, Your Honor.
Are you ready? Do you have your people today?
No, sir. I saw that it was set just to announce that she was found competent. I guess that's what I was looking
Or we'd ask the court to revisit the issue of bond on the. I know her mother is desperate to have loans.
All right, I have a letter from Dr. Edgar Pond dated May 22nd, 2025, where the defendant was evaluated for competency, and the evaluation resulted in his determination that the defendant is competent to proceed to a resolution of her legal issues. I'm going to call this Court's Exhibit 1. Today's date. 6/6/25. And it is made a part of the record for all purposes, and we'll keep this in a sealed form. Any objection to its?
Without objection.
All right, is it made a part of the record for this case? The defendant, this motion to revoke probation began its journey on March 8th of 2024, when the defendant was alleged to have 5 violations of aggravated assault, resisting search, harassment of a public servant, all on February 13th, 2024 in Jefferson County, Texas, and failing to comply with program guidelines and rules of the Moral Recognition Therapy Program, which is good. It helps people make better decisions. And then failed to pay court assessed fees and was in arrears in her required payments for probation and other fees. Then a first amended motion to revoke probation came along April 22nd of 2024 and added allegations 6, 7, and 8, it is alleged that on March 19th, 2024, which would have been about a month, a little over a month after the first 5 allegations allegedly occurred, that she committed the offense of resisting arrest or search. March 19th of 2024 in Jefferson County, Texas, committing the offense of public intoxication on that date in Jefferson County, Texas, committing the offense of injury to a disabled person also on that date. And the defendant is on deferred or unadjudicated probation for the 3rd-degree felony of injury to a child or disabled person or elderly person, and it would be what? No, talking about which of those elderly person.
Yeah, yes or no.
Can we have this hearing as soon as possible?
We can have it within a week, Your Honor.
Okay.
It shall be done. All right. Huh? 17th or 18th? Y'all pick.
Would they,
Today's 6th.
This 17th, I'd say.
That's going to be week after next.
so Friday or Thursday? When?
It's a Wednesday. It looks like a Wednesday or
Tuesday and Wednesday.
Wednesday or Wednesday. All right. It's set for Wednesday, 17th?
8.
18th. Okay. Here is the order on the finding on Rapon. Dr. Rapon, that needs to be placed in the
Yeah.
seal envelope. And also 24 CR, the new 530, the new indictment on harassment of a public servant that will roll with the motion to revoke probation. Shelby Solorendi. Let's see. We got 1, 2. She's on 3 probation.
Yes.
Okay. I don't see a new indictment. These are just 3 probations where motions to revoke probation have been filed. First amended motions to revoke probation, by the way, all filed in each of these 3 cases on March 24th, 2025. Cause numbers 23 CR 2129, 24 CR 37, and 24 CR 2001 are each called the State of Texas versus Arlie Champagne Weaver. That's you.
Yes, sir.
Present with your attorney, Mr. Kimmler, and the state's attorney. Does the defendant waive formal readings of these motions to revoke probation? Can we proceed in summary?
She does when Mayor.
Raise your right hand. Do you solemnly swear or affirm any statement you make during these hearings will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lawyer. There's some similarity here on 23 CR 2129 and 24 CR 37. In summary, each of these first amended motions to revoke unadjudicated probation in these 2 cases similarly state that on February 5th, 2024, in this criminal district court, you were placed on 5 years deferred or unadjudicated probation for the state jail felonies of theft in 2129 and unauthorized use of a motor vehicle in 24 CR 37. Are those allegations true and correct as they are alleged now? We've got 8 violations. Where are we proceeding? Did y'all talk about
We
that?
haven't touched it. I would just go through the she can have please and true and not true.
Yeah.
That's
So what?
Well, if you would just read someone out there and she can have please.
Okay. She hasn't entered any pleas prior to this, correct?
I believe that she had on 1, 2, and 3 because we held it in abeyance in October of 2024 to place her on the new probation in 24-2001.
Actually, there are no findings on any of these motions to
That's fine.
revoke probation. Okay. All right, so let's take them up. 1. States she failed to report to the Jefferson County Probation Office for the months of April, May, June, and July of 2024. And that is similarly alleged in each of these 2 cases 23 CR 2129 and 24 CR 37. And that was in violation of your probation order. Is that allegation true and correct in each of these cases? Are you pleading true and correct to that voluntarily and because those allegations are true as they are alleged? You understand that a violation proven by a preponderance of the evidence or greater of one or more violations of probation, that is enough to grant the motions to revoke probation. Probation can be revoked and you can be sentenced up to the full range of punishment in each of these cases, which sure on site that. Which are state jail felonies, not enhanced. So you're looking at, in each of these two cases, if your probation is revoked and you're sentenced, you're looking at no less than 180 days up to 2 years in the state jail. In each case, knowing that, do you insist on pleading truth today?
Yes.
I find you're pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yep.
Stand by. Happen to these new substantive offenses, and looks like it's numbers 4 and 5.
Which
Assault, family violence, December 21st, 2024. Illegal possession of a controlled substance, February 17th of this year.
is it Orange County?
I didn't say.
It says in Jefferson County. That is not her Orange County offense. It's a Jefferson County
Yeah,
offense.
it is Jefferson County.
The assault was refused from our office. The possession is still waiting for drug results.
Okay. And let's go number 2. This alleges in each case, this violation that you failed to provide verification of performing community service hours as required in each of these 2 cases. Is that allegation true? Pleading true to that voluntarily and because it is true in each case. Understanding that that also has the same consequences as what we talked about in your plea of true to allegations number 1 in each case. Let's hold all of that and go to this third one, 24 CR 2001. And again, she waives a formal reading of this motion. We can proceed in summary.
She does, Your Honor.
This one was more recently filed on March 24th of 2025. And again, this states that on October 28th of 2024, you were placed on 5 years deferred or unadjudicated probation for theft of service, a state jail felony. Is that true? And allegations 3 and 4 allege that you failed to report to the Jefferson County Probation Office for the months of November and December of 2024 and January of 2025 in violation of condition 4 of your deferred adjudication order in this case. And allegation 4, you failed to provide verification of performing community service hours as required in that case. Or allegations 3 and 4 in this case number 24 CR 2001. True and correct as they are alleged, and are you pleading true and correct to those voluntarily and because they are true?
Sure.
Yes.
Find you're pleading true voluntarily and you admit that they are true as alleged. All right. Are there agreements on this?
No, Your Honor. It is
Go
to
ahead.
court. She was bench warranted over here from Orange County. Judge Parkhurst in the 260th court has sentenced her to probation and ISF on the
Burglary of habitation.
Okay, was it older?
From that all these crimes are committed.
It was I guess an older burglary of a habitation case. And so she had these motions to revoke pending, so she was brought over here. She's 5 months pregnant, and it's my understanding, of course, I'm not an expert on these matters, at least on the female end, but that she has a high risk pregnancy. Again, I'm not an expert, but that's what has been related to me. And in any case, whether it's a high risk or not, ISF won't take her. And so I'm going to have to get with the 260th of Judge Parkhurst to see how he's going to proceed on
How
that.
many children do you have
One.
already?
Yes,
This will be your second?
yes, sir.
How old is your other child?
7.
Ma'am?
7.
So I don't think that ISF or SAP is an option if she's continued on probation. Again, my suggestion would be, I guess, to get an updated pre-sentence report so the court can be aware of what her current situation is and how she's
On
obstacles that she's had while on probation before you determine whether
On- these cases, is there any restitution?
No, Your Honor.
No? On
Not that I believe.
either?
I don't believe so.
I think she would benefit from inpatient rehabilitation. I think you would agree with that, is that right?
Yes,
Have
sir.
you spoken to Franklin House or you?
Yeah. Yes, sir. I was there before, the day before I went to court in Orange County. And I've been in jail since then.
So you put yourself into rehab?
Yes.
I'm sorry, Your Honor. She has $250 restitution in 2129.
You able to pay that?
I would think her family can be able to pay that, Your Honor. I'll represent to the full years.
When?
They hear anybody?
Here.
Would you be able to pay $250 restitution?
Excuse me, Your
There's
Honor.
also other restitutions.
There's another restitution. The cause number 2001. The amount of $3,200.43. So she has 3 cases.
I understand. Two. Yeah, two. The first two were when she was placed on probation on February 5th, and the third one when she was placed on probation on October 28th
Yes.
of 2024.
The total restitution is $3,000. Who's the 3,000? Who is that?
It's not written in that order. So I don't know. I don't have the old case with me.
To reset it for sense. See what.
No, let's see what she has in accrued time right now, and I've got a
Well, I
plan.
know the court's out of that restitution.
I know. And they're going to, her family can pay that first restitution. What I want to do is dispose of these two
I see.
and then keep her on.
I understand. I see where you're going.
Looks like our warrants were cleared pretty quickly, so she was in other places, but our warrants weren't.
She's got 165. So you see, you see what I'm going to do.
Yes, I understand.
All right. But the restitution has to be paid, or I'm going to undo it by the end of the day.
That's the 250 or?
Yeah, that 250.
250.
Yeah.
Well, hang-
Yeah, he's going to tell you how to do it. Yes, ma'am, and we'll help you navigate through this so it can get done. Because the court has a plan here to try to whittle down these problems. Okay. All right. Anything else to add?
No, no.
Okay. Let's take up 23 CR 2129 and 24 CR 37. The court finds in each of these two cases that you have pleaded true in this first amended motion to revoke unadjudicated probation in each case voluntarily, knowingly, intelligently, to allegations 1 and 2 of the motions failing to report and failing to provide verification of performing community service hours. And you have admitted that voluntarily, knowingly, intelligently, and understanding and appreciating the consequences of pleading truth to those. That is enough to grant these first amended motions to revoke unadjudicated probation by a preponderance of the evidence or greater. And the court grants these first amended motions to revoke unadjudicated probation, and your deferred or unadjudicated probation is hereby revoked by this action. In these cases, on February 5th, 2024, in each of these two cases, you pleaded guilty to theft of property, a state jail felony in 2129, and unauthorized use of a motor vehicle in 24 CR 37. You made those pleas of guilty voluntarily, knowingly, intelligently. There was sufficient evidence supporting the guilty pleas from State's Exhibit 1 admitting in each of those cases to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in those two cases based upon these violations of probation, and you are hereby sentenced to confinement in the state jail for 180 days. That's the minimum you can get. You will be given credit for 165 so far. So you see, you've got like 2 more weeks that you have to finish out the sentence. And restitution in the amount of, was it 200? What was the amount?
$250.
$250 is ordered to be paid in the judgment, which needs to be paid on or before the end of the day so that she can be released when she finished, as soon as she can finish these 180 days. That is in the amount of $250 to the complainant in 23 CR 2129 as her name is written in this indictment. Please get with the family members so that they get the name correct when they submit it for restitution. They send it to the probation office?
Yes, sir.
Yeah. You go to the probation office, which is not far, you go a block or so from here.
I'll explain it to you.
And there's a form a form of payment that they take, and we'll do that. We'll accept that. That resolves those two cases. On this motion to revoke unadjudicated probation in 24 CR 2001, the defendant has pleaded true to allegations 3 and 4 of this motion to revoke probation voluntarily, knowingly, intelligently, and that is enough to grant this motion to revoke probation by a preponderance of the evidence or greater. And these are allegations of failing to report to the probation as required and failing to provide verification of performing community service hours. Again, the court finds that is enough to grant this motion to revoke unadjudicated probation by a preponderance of the evidence or greater. Your deferred or unadjudicated probation is hereby revoked. Earlier in this case, you pleaded guilty voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony, and you are hereby sentenced to confinement in this state jail for a term of 1 year. That is suspended. You were placed on regular probation for 2 years. There will be terms and conditions of probation that you need to follow so you can get released off of that early. But we're doing this because you are going to be released here on this one. You got to just serve 15 more days on the other two to satisfy those two by law. Then you'll be released, but you'll be on probation on this. And the key thing is you got to report or else you're not on probation. You have to pay the restitution back. Quicker you pay the restitution back, get you out there, get you to get an income, be responsible, fix your messes. We all make messes. We all make mistakes. We have to fix them responsibly. That's the test for character purposes. We're helping you do your best, the best you can be. You understand where we are on this?
Yes, sir.
Okay. So,
Yes, no, Danielle is 2010. Yeah.
but that restitution is owed in an amount of $2,500. Did I say 2,000 or 3,000?
There's three, Your Honor.
$3,500. But you got to get that done before the end of probation, and the quicker you get it done, the quicker. That's the key to this case. When you pay restitution back, I consider releasing you early.
Yes. Thank you.
Yes, ma'am. Okay. Everybody understand where we are on this?
Yes, sir.
Okay. Any questions, ma'am?
No, sir.
All right. Good luck to you.
Thank you.
Good luck.
But on strict cooking.
I don't. Well, you had to take them in
No. It's good.
installments. Then.
So there's that's what I know.